You're watching Bloomberg Law. I'm Pacchia. As I'm sure you all know, the United States Supreme Court handed down its decision in the Affordable Care Act case a couple weeks back. To the surprise of some, the court decided to uphold the individual mandate provision under the tax power rather than the Commerce Clause. What does this all mean for the future of Commerce Clause jurisprudence? We're asking Robert Schapiro to find out. Robert is Dean and Professor at Emory University School of Law. He's appearing via Skype in Atlanta. We're very happy to have him join us. Welcome.
Happy to be here.
So, before we jump into the Commerce Clause right away, I wanted to ask what you made of the decision in its entirety. Were you surprised that it leaned so heavily on the tax power?
I certainly was. I think the taxing power argument had been there from the beginning, but boy, it really hadn't gotten much play in the lower courts and didn't get much time in the Supreme Court. So I certainly was surprised that in the end, that was the basis for upholding the law.
What are the implications of Chief Justice Roberts' treatment of the Commerce Clause in this case? It didn't ultimately decide the outcome, but there's a lot to sink our teeth into there. What jumped out at you?
Right. Well, in some ways, we have to separate a little bit from the actual matter at issue in the Affordable Care Act case and then what maybe we'll see in other Commerce Clause cases. Because as the challengers of this law consistently said, it was a bit unusual to have a statute mandating people to do something like purchase a commercial product, in this case, health insurance. So in some ways, an opinion saying under the Commerce Clause, Congress can't mandate you to do something might not have that much significance in the narrow sense. But in a larger sense, it's clear that there's a certain skepticism among the 5 justices on the court about what Congress might do. So we might see other kinds of statutes that are challenged, not exactly on the activity versus inactivity line, but more generally thinking about a new skeptical view of the Commerce Clause. And here I'm thinking particularly about environmental statutes. That's often been the focus of debate, since in the environmental area, it can be a bit tricky to characterize what's being regulated as, say, commercial activity. So when you say you may not kill the red wolf, well, it's what is the commercial activity being regulated? Perhaps it's a regulation of the overall market in red wolf pelts, which is to say to ban it. But those Commerce Clause arguments can be tricky, and I'm sure some people will see these opinions as an invitation to challenge those environmental laws.
Is there a particular case on the horizon, say in the next term or the one after that, that would potentially touch on these issues? And if so, which one?
Yeah, not yet. I think that we see some cases kicking around in the lower courts under the Commerce Clause, although those are mainly following the Rapanos case in 2006, which was about under the Clean Water Act and what counts as a regulation of waterways as opposed to regulation of land. But I think what we may see now are new kinds of challenges. There'd been a certain amount of settled law upholding a variety of statutes, and I think it'll take a little time for those new kinds of challenges and the new legal theories to work their way through the system.
Were you surprised by the vote here at all? It turned out that Chief Justice Roberts, rather than Justice Kennedy, served as the pivot vote in this instance. A lot of people were thinking it was going to be Justice Kennedy or perhaps Justice Scalia that would be the deciding vote, but instead it was Chief Justice Roberts. What do you suppose happened there?
Yeah, well, it certainly surprised me. I guess as we've now realized, this has been the only case in which Chief Justice Roberts has joined the 4 liberal members of the court. I think it seems likely that Chief Justice Roberts felt that this was a very important case institutionally for the Supreme Court, and he was going to think long and hard before striking down this major piece of social legislation. You really have to go back to, 1937, when you see the Supreme Court strike down something like this. And so one has to think that the institutional role of him as the Chief Justice really came into play. And he had, during his confirmation hearings and at other times, talked about trying to remove the court a bit from politics. You had the sense he was concerned about the court being viewed as a partisan institution in the wake of the Bush versus Gore election decision in 2000. And so perhaps this was an opportunity for him to show that the court is not a partisan institution. It's above politics in that way. I want to be clear. I no reason to believe that Chief Justice Roberts was in any way insincere in his adoption of the taxing clause arguments. But one has to think that perhaps in the back of his mind, as he was looking at the law, it would be hard to keep these larger institutional considerations out of his mind.
It's certainly an interesting end to a fascinating process that took months and almost, of years to play out. We're certainly glad to have your thoughts on that. But while we have you here, we'd also like to get your thoughts on how things are playing out in your neck of the woods. What does enrollment look like this upcoming year for Emory University School of Law? Is it up or down?
Right. Well, it's a very dynamic time. Actually, our applications were not down this year. Nationally, applications were down 10 to 15%, not down here. And so we think we're going to be on track for what we plan to be our usual enrollment. But what we're not sure about is, given the decline of applications at other schools, whether things will be a little more dynamic this summer, as maybe other schools going to their wait lists, or there was an article I saw about maybe schools coming out and offering more financial aid to try to entice students who've accepted at other schools. So that's really what we're waiting for. At the moment, things seem pretty much business as usual, but we're just concerned about how the dynamics may play out in light of the national trends.
Mm-hmm. What about scholarships? Is Emory going to give out more or less than they did last year in terms of money?
I think it'll be about the same. We've been able to be fairly generous with our scholarships, and it's certainly very important for us to keep tuition affordable, to make law school accessible to as many people as possible. So there's really not a possibility for us to reduce scholarships at this time. And with the support of our alumni, we think we'll be able to keep it up where it was in the past and where I think it really needs to be.
As we were saying before we jumped on camera, this is a particularly trying time for law students and recent grads. Could you talk to us a little bit about how they are navigating these difficult times coming out of Emory and going into the workforce?
Right. Well, I think the changes in the legal profession have had a particular impact on the entry level, as we see the big firms with fewer first and second year associates because the big companies say they don't want to pay for those first and second year associates. And so the challenge has really been to try to equip graduates to be able to make an easy transition into the workplace in a variety of different settings. And so what we've tried to do is to let students know that a lot of the exciting work being done now may not be at the big firms, maybe at smaller firms, more boutique firms. The challenge for us is to make contact with those firms and to bring Emory students to their attention. And then what we do is help our students to be able to prepare themselves for those different kinds of settings. You know, it used to be, I think, students would graduate from law school and then begin to think a little bit about what they wanted to do and maybe go into a big firm and get a general kind of training. What we're trying to do now, though, is from the moment students enter is to say, let's think a little bit about what you want to do with your legal education, what courses you want to take, what contacts you want to make in law school, what field placements or practical training to get. So then you can find perhaps those smaller firms, those boutique firms, and be able to make that kind of transition. So it's put more focus on getting students ready while they're in law school to begin to develop careers that will take them into their first job and then a satisfying career afterwards.
Yeah, I think it takes a lot more planning to navigate these choppy waters, so to speak.
Exactly. That's a great way of putting it.
All right. Dean Robert Schapiro from Emory Law School, thank you so much for your time today, sir.
My pleasure. Thank you.
If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube and follow our updates on Twitter. I'm Pacchia. Thanks for watching.